Assalamu alaikum, everyone. Good afternoon, or not even good afternoon, good evening. And thank you so much for joining Muslim Wills, Australian Wills and Estate Planning Seminar. Inshallah, we'll be starting in a few seconds. We're just waiting for just a few more people in the waiting room to enter the lobby, inshallah. All right. Bismillah, let's get started. Firstly, Jazakumullah khair, and thank you so much for your attendance at tonight's seminar. I'd like to start off by acknowledging the traditional custodians of the land on whom we meet and pay my respects to elders past and present. Tonight, we have a very esteemed guest with us for a very, very important topic of wills and estate planning, specifically within the Australian context. We are joined by Ramia, who is a lawyer and the founding partner at Law Bridge Lawyers. She has close to 20 years experience in wills, estates, planning and probate matters. And a lot of you would have encountered her work through outreach, community advocacy and education for the last few years or decades. And was one of the, one of the only people, actually bringing attention to this very, very important topic all along. So inshallah, by way of housekeeping, I will ask everyone to please ensure that you're on mute at all times. The format for today's session will be that Ramia and I will have a discussion-based conversation around wills and estates and the preliminary topics that we'll be covering. We anticipate that to go for about an hour or just over an hour. And inshallah, what we'll have is an open Q&A at the end where you're welcome to turn on your mic and ask a question directly, or feel free to write questions in the chat box as the seminar is proceeding, which we will get to at the end of the seminar at Q&A time, inshallah. Please be mindful of the fact that we are discussing, a very specialized and nuanced area of law. So if you don't get it off the bat, it's not you, it's actually the topic. So alhamdulillah, what we'll be doing is we are recording this session, and we will make that available to attendees at the end of the session. So if something misses you, or there's a point you want to elaborate on, don't fret. Inshallah, you'll have access to the recording at the end of the session. So without further ado, I wanted to welcome my guest Ramia. Jazakallah khair. Thank you so much for joining us, Ramia.
Assalamu alaikum. Jazakumullah khair for the opportunity.
Ramia, let's get right into it. So what I have on my screen is a seminar overview. So this is what we'll be covering in today's seminar, inshallah. Why is a will needed? The nuances and differences between Australian law and Islamic law, the components of a valid will with the emphasis of validity from an Islamic as well as legal perspective. We'll be talking about how the distribution of the estate works upon death for you to be able to understand how to plan for that through your will. We'll be dealing with wills of converts who, from an Islamic perspective, present their own set of challenges and complexities which people need to be aware of. Then we want to really hone in on what makes what the average person would deem a simple and straightforward estate or will complex. And inshallah, we'll be covering things like testamentary capacity, trust, businesses and companies, issues relating to children, lifetime gift or hiba, which is an Islamic concept, and superannuation as well as insurance. And inshallah, at the end, I will do a quick overview of the MuslimWills platform, which is our catered solution designed by Awqaf Australia, which helps you put together your simple will for a simple estate. And in the event someone has a complex will or has complex needs, depending on what based on the issues that we raised today, then Ramia, as well as some of our other law partners, are happy to be able to further that conversation with you in relation to having your will legally drafted through a solicitor. So inshallah, in today's seminar, we'll be able to give you some food for thought and some areas for you to think about to be able to make informed decisions about your estate planning needs. So Ramia, the average person, and I think the average person, I would say either young people who might not have, properties or assets. or the average person who might be older but still not have assets or property might tell you, well, why do I need a will? Like, what is the necessity of the will? So can you run us through the importance of a will from an Islamic as well as legal perspective, please?
Yeah. So I guess we get that question posed to us often. I don't have any assets, or for example, there's not much to give. Why should I have a will in place? I mean, first and foremost, particularly for Australian Muslims, it's really important that we realize there are certain things that will form as part of the instructions that we ultimately stipulate in our will, which are out of the ordinary. So whether it's funeral and burial rights, whether it's guardianship and, care for children with special needs and so forth, the list goes on. Specific shares of allocation in terms of your primary beneficiaries and so forth. First and foremost, we don't live in a Muslim country, right? So we live in a Western, I would say, secular country that does not really compel or oblige anyone to have a will. It's not compulsory under the Australian legal system to have a will in place. It is optional, right? Under the Australian legal system also, you can do whatever you want in terms of distribution and instructions, which opens a whole heap of other legal challenges, such as family provisions claims and challenging one's will for whatever reasons, be it exclusion or testamentary capacity and so forth. Apart from all of that, first and foremost, I guess, the instruction to have a will in place comes ultimately from Allah Azza wa Jal. Allah instructed and commanded us, as per, within Surah Al-Baqarah in verse 180, to ensure that we have a will in place and to ensure that we are actually allocating the relevant shares, which is pre-set in the Quran, but it's that 1/3 wasiyah that's somewhat voluntary. And secondly, emphasize about the Prophet ﷺ. So the Prophet, peace be upon him, as per prophetic hadith, has told us time and time again to ensure that we do not obviously, let 2 nights pass without having a will in place. That, in taking that in mind, we realize that, and we get all these questions, yeah, but I've told my children, I've told my beneficiaries verbally what my instructions are. That is ultimately not going to be enough. And we will talk about the legal requirements of a will and what's expected, but ultimately, we just and the other issue, sorry, I wanted to raise very quickly, because these wills are beginning to surface now when we come to apply for probate. For parents, and if any of our listeners today have parents, particularly that arrived in the 70s and 80s, back then, most wills, we didn't have many Muslim lawyers, but we're very privileged at this point in time to have Muslim lawyers who are somewhat familiar with drafting Islamic wills. So at the time, they were seeing either white or non-Muslim lawyers who would ultimately draft wills and simply instruct in those wills, I hereby leave my estate to be divided in accordance to Sharia law. Literally, that's all that there is in the will. And what's happening now is we're seeing those particular wills being challenged somewhat or questioned by the court. So I was actually, engaged by a Victorian law firm whereby a Muslim family had beneficiaries who were in dispute as to what their mother's instruction of in accordance to Islamic law actually meant. So we had to sort of furnish the courts with evidence of what the different, schools of thoughts are and were at the time, and give them instruction as to, based on the Islamic shares that are apportioned, what each beneficiary would get. So if you have a will that simply says something like, my estate is to be divided in accordance to Islamic law, that is not enough. We're not in a Muslim country, and the court system and the legal system here does not understand what Sharia law actually is.
So, Ramia, can I ask, if I passed away tomorrow and I didn't have a legal will that covers the components which you'll cover, legally, what happens to me?
Yep. So you would have passed in a state of intestacy, so technically what that means is you've died without a will. And according to most state laws have very similar, I guess, rules or legislation around the issues of intestacy. But in New South Wales in particular, it works by sequence of order or priority. So for example, if you have passed and you have a husband, everything technically goes to him. If he's not around but you have children, everything goes to them, but it is split equally between them. So automatically here, that Sharia component is removed, because the boy would not otherwise get double the share of the girl, and the list goes on. there's this taboo, I guess, or myth. I do get clients who call often. It's to our advantage as lawyers, but I always try to clarify. They ask, I want to do a will because if I don't have one, the government's going to take everything. That's not going to happen if you have beneficiaries in place. But what actually happens if you die without a will is technically your estate will either go to one person or your beneficiaries equally and without any consideration to the Islamic requirements that would otherwise apply if you did have a will.
And the second part of the question is, if I passed away and I had assets in my name, so for example, I had a house in my name, is there any way to bypass the court system and have that distributed, or do I need to go through the court system? I know you mentioned the word probate, which is what I'm trying to get at. So can you please explain probate and the fact that if somebody does pass away and they have assets, it's not just a matter of your family dealing with it and that's the end of it?
Yeah. So a lot of people think that once a person drafts a will and that person passes away, a magic fairy sort of pops out and automatically executes the will. What they don't
Or
realize
even, for example, they didn't have a will, they pass away, and then they just assume the fairy will come along and distribute the house. Yeah.
Yeah. So I have clients literally who have sat on assets that belong to the deceased for 10 years, assuming that because they had a will in place, it was automatically in their name. And as you know, once we actually conduct title searches on real property or houses, we realize the assets are still held in the deceased's names. So here, I guess, I mean, this is a very long topic, and it's that if we're talking about real property or assets by way of, houses or land, the tenancy arrangement or the ownership arrangement will really matter here. So if you are joint tenants in this scenario, technically speaking, and if that's your only asset, you don't need to go through probate. What probate is literally just the executor providing the court with the will as well as other evidentiary documents to pretty much seek permission and authority from the courts to go ahead and execute the will and then administer the estate. That's what probate is. And most often you would go through lawyers to undertake that process. Costs are usually scaled by the courts, as well as the filing fee that is scaled in accordance to the value of the estate. Now, if you had an asset, say for example, your only asset is a house that you and your partner own by way of joint tenancies, here automatically real property laws take precedence. All that is required is a lodgement of the death certificate with the Land Registry Services, and you will bypass the probate process. Now, that's all great, but it is also somewhat, and some actual contemporary scholars talk about this concept as potentially being conflicting with Islamic law, in a sense where you are not going to then be able to give your beneficiaries the rights that they're entitled to by doing that. And it becomes problematic if it is a second marriage. So say, for example, the mother is not the biological mother of these children or vice versa, and hence she or he has taken ownership of that property, thereby excluding the children. So there's a lot of questions to ask your, at the time, conveyancer or property lawyer when you even purchase property, to ensure that the ownership arrangement is somewhat compliant with what the law says, Islamically speaking, when it comes to inheritance and distribution.
This is something I want to come back to when we're talking about complexities and the issue of lifetime gifts or hiba. So I just want to park that and come back to it, because I think the average person who's purchased a house, they might be married for 20, 30 years. If you actually ask them what is a title arrangement, they probably don't even know the answer.
No.
And most people, especially if it's a couple that have purchased the house, they would have just gone with a joint tenancy situation by default, not appreciating the effects that has on the Islamic distribution. So I want to park that, and for our listeners, we will come back to that point. But I think it's just easier to address it later when you understand how the Islamic system works, to be able to understand the complexities around that arrangement. So that sort of is a nice segue to our second topic, which is the Australian framework for estates and wills and the Islamic inheritance principles. We've obviously touched on number one, which is the actual distribution. The Islamic system has a preset distribution mechanism as outlined in the Quran and the Hadith. The Australian law has estate system, which is differs from state to state, but generally, as you said, spouse gets it, if not then spouse and children. What are other differences that are there in the Australian and Islamic distribution and inheritance systems that our listeners need to be aware of?
Yeah. So just as a complete side or footnote, my passion for this topic actually arose when I did a thesis on a comparative between the Australian legal system and the Islamic inheritance system. And it was
So can you condense your 2-year thesis?
Yeah, it was, I guess, an attempt to myth bust, because there is this misconception that the Islamic inheritance code is oppressive, it is unjust, and it is too controlling, in a sense that a deceased Muslim does not have autonomy or testamentary freedom to the same extent that a non-Muslim would. And my hypothesis, based on, you know, case law and particularly family provisions cases that came through, showed that in fact, in the end, you may end up with more testamentary freedom and autonomy as a Muslim, because you ultimately have that 1/3 to deal with. And it is not an emotive or emotionally based system. So, for example, under the standard Australian legal system, if my children have not visited me for Christmas, I'm going to exclude them from my will. That then triggers a whole heap of things. My children, once I pass, will definitely challenge my will definitely most likely get it sort of reassessed, potentially voided, and hence then your wishes are in the hands of the presiding judge on the day in which your matter is heard. Your testamentary freedom has completely been eroded in that circumstance, and hence a decision has been made for you. So I know at times, and it's not until you delve into the wisdoms and the hikmah behind absolutely every command and divine instruction that we have been given under the inheritance code in Islam, that you come to realize actually it is very, very fair and just. And there's this notion that I like to share, particularly when I have female clients who come in and say, I do way more than is expected of me for my parents than my brother would, yet he would get more at the end. And I say, well, ultimately Islam is perfect, but Muslims are not. We're not going to change our preset scripture and rules just because we are not perfect, and we need to progress, sort of, you know, perfect and improve our condition and state to work towards that. So ultimately, under Islam, you have autonomy only over the 1/3 aspect of your estate, right? Whereas under
so Islamically, your estate is divided into thirds. So 1/3 is wasiyah, which you said is discretionary. And then what happens to the 2/3?
The 2/3 will ultimately go to primary beneficiaries, depending on who is alive at the time of your death. So, for example, if, you know, the wife passes away, her husband, her parents, her children are all primary beneficiaries, and the list goes on. In the absence of those, there are other certain entitled primary beneficiaries. The other plot twist here is that you cannot gift anyone or grant or bequest to any of your primary beneficiaries from that 1/3. So as far as I'm concerned, that 1/3 can be allocated as a sadaqah jariyah. And we really recommend and advise clients, because this is ultimately the time in which you have control over where, you know, that direction that you're ultimately going to, your ticket potentially to Jannah, right? In a sense where don't depend on your beneficiaries to pay a sadaqah on your behalf. Your 1/3 is the ticket, and you have that power and authority to do that if you choose to. You can gift it to a mosque, a project, you can gift it to a hospital, or if you have a distant relative or friend who is in need of financial assistance and they've been good to you, you can also gift them or bequest them from that 1/3. But none of your primary beneficiaries can get any of that. One of the other errors that we fall into, by the way, from an Islamic standpoint, and this is where those 1970s, 80s wills are also presenting, is that there is a clause in there that says, in the event that my child has passed before me but leaves children behind, then that child would otherwise inherit basically what that parent would have been entitled to. That is not Islamic. Ultimately, from an Islamic standpoint, that child's share should go back into the pool and their siblings inherit, but you can leave for your grandchildren from that 1/3. Does that make sense? So there's a lot of things that we don't realize are actually, you know, they're straightforward, but unfortunately they've been blurred and confused as being Islamic over time. But ultimately, that's not what the code tells us. The other most important comparative is the burial and funeral arrangements of the deceased. So technically, under the Australian Code, do you know, Tess, I'll ask you the question, what's the most common method of burial these days? Do you know what the most opted for is?
I think cremation.
Cremation. Why?
It's cheaper, quicker,
Exactly.
get them out.
So cremation's actually on the rise. Sorry that I'm asking you.
No, it's really important. SubhanAllah,
Yeah.
I was actually looking up another case in which a revert sister's body was held by the coroner at the morgue for over 6 months because the convert and the family were arguing over the tombstone.
Yes. Yes.
So what you mentioned in terms of Islamic burial instructions is people think, okay, really, but these are live examples. So as you said, cremation, in the absence of very clear instructions as to what you want, what's stopping someone from opting for that easier or cheaper process?
Yeah, and this is particularly an issue for revert brothers or sisters. And we had a live case study that took place in 2015. It was a revert sister who had embraced Islam, but she had not notified her family. She was unmarried. She did not have any next of kin. Her next of kin were ultimately her family, her parents, who did not know that she embraced Islam. She was diagnosed with a terminal illness within months of embracing Islam. She passed away, and the family, insisted that she be cremated. And there was a bit of a sort of a fight very temporarily for a few days between the Muslim community members and the parents or the family. It was then, I guess, agreed on that, ultimately, legally speaking, they are the next of kin and they will get the ultimate say as to how it is that she would get buried, and she was cremated. So cremation, also embalmment, by the way, embalming is a notion that we are very much unaware of just how common it is in our community, particularly within the older, the elderly within our segments of our community. There's this almost desire or preference to want to be buried in the homeland. But what they don't realize is actually you need to go through the embalmment process. If you have courage to watch a YouTube clip on what embalming actually entails, you would come to realize just how invasive it is, how undignifying it is. All scholars, both contemporary and classic, of the agreement that it is completely forbidden and prohibited in Islam. And most embalmers in Australia are actually males. So imagine females or sisters who are put on that table to be ultimately exposed and embalmed to be buried in their homeland. It defeats it. There's no I guess there's no regard
Reason why it should really,
or reason. Yeah, absolutely.
So just to clarify for our listeners, embalmment is the legal process in which the body is prepared chemically to be able to enable it to be transported.
Yes.
And legally, without that embalmment taking place, the body cannot be transported. So for those who have end of life wishes in relation to where they want to be buried, that embalmment process is something that has to happen. And what you're saying is Islamically, that's complete contrary to how the body should be dealt with upon death. So let me just clarify. I think to sort of make it easy for our listeners, 3 points really. Number one is the Islamic system of distribution is vastly different. So that's the key difference between an Australian and an Islamic system. Number two, Australian law gives you absolute discretion over your own estate in terms of who it goes to. However, that has issues in and of itself, as you outlined, in terms of family provision claims and challenges. Whereas the Islamic system allows you discretion over 1/3 of your estate in terms of who that goes to, and the other 2/3 are prescribed according to the Islamic requirements. And number three is preparation and dealing with the body, everything from ghusl to transport to burial to even funeral practices after the body is actually buried. These need to be stipulated, and there is a difference between, I guess, cultural norms or Australian, default options and our Islamic principles. So having thought about all that, now we come to the daunting task of, okay, so what do I need to have in this magic wheel to be able to cover everything that you've just gone through? So can you just give us, in terms of just as an overview, what are the essential components of a will to ensure that legally and Islamically it's valid?
Yeah. So first and foremost, it must be in writing. Our traditional methods of I told my son or my daughter that, you know, to deal with my estate in such and such a way is not going to sort of be acceptable. It must be in
Or
writing.
even, sorry to cut you off, Ramia, there was that case where the really famous actor had just a note on his iPhone.
Yeah,
It was just a typed up note. It wasn't signed, it wasn't executed, and that
yeah,
was sort of the last remaining document. And it's
yeah.
an absolute nightmare.
Yeah.
So the
It's going
format
to be
of the
open to
will.
interpretation, right? It's going to be open to interpretation. But it must be in writing. It needs to be obviously signed. It must be dated. And this is relevant specifically. We'll talk about why date is important, but more so centered around the notion of testamentary capacity. One of the most, I guess, controversial Muslim case law matters that went through the courts and, you know, was questioned on this notion was the case of Omari and Omari of 2012. It was centered around testamentary capacity at the time. So this was a family who the mother, Muslim mother, drafted an Islamic will. One of the children, the daughter, had actually challenged the will on the basis that her mother lacked mental or testamentary capacity at the time in which she signed. And it was ultimately, you know, challenged and then deemed as void, whereby all the beneficiaries were granted equal shares. Of course, the media, you know, misconstrued the reasons as to why this will was cancelled or voided.
Set aside, yes, yep.
Yeah, on the basis that, look, Sharia law is so oppressive
Yes.
that even the judge decided to void it, but that's not the reason. It was about mental capacity. So date is important. It must be witnessed by two people over 18 years of age, and preferably the parties must sign all the pages. Now that's what the will is to look like. What do we generally cover within the will? We allocate a role for your executor, and the executor is going to literally be the most important person in your next life, right? In your death, in that they will manage and execute your estate or effect the will in your absence. So they have to be very trusted. They have to be aligned within the same sort of value sets and principles that you operate on. We have a preference, if you have a good relationship, obviously, with your spouse, that you allocate one another or you sort of delegate that task to each other, and then have a backup executor. They have to be over the age of 18 and obviously of sound mind. We then go and set out the beneficiaries' details. We also set out the funeral and burial rights, and this could be, you know, sort of expanded as much as you like. Who you'd like in the washroom, who you'd like to do your ghusl, what you'd like to happen at your janazah, who's to lead your janazah, what your funeral is to look like over the next 3 days, and the list goes on. Debts and expenses are also accounted for, and in an Islamic will, bear in mind, does not forget about your debts owed to Allah. So we're talking, you know, Australian will talks about debts and expenses owed to people, to, you know, third parties and so forth. But the Islamic will go as far as to stipulate any unpaid, for example, zakat, any mahr that you have not, you know, passed on to your spouse and so forth. We then also allocate specific fixed shares to the beneficiary. So at the time in which the will is drafted, we work out who is alive at the time in which you are drafting the will, and we set out the Islamic percentages. Now, obviously, if your circumstances change, you need to update your will. And we do recommend that a will is a document that's sort of visited at least every 5 years. It's not something that's going to cost you thousands and thousands of dollars. So hence, you should actually visit it every 5 years, just to make sure that everything is up to date in terms of beneficiaries and assets and so forth. Guardianship.
Also, sorry to cut you off. 5 years, and
Yeah.
also that are life-changing events, because Islamically it actually changes the distribution. So
Yeah.
things like marriages, divorces, children being born, and things
Yeah.
like that, they actually
Yeah.
Islamically alter the family unit, which means that the 2/3 of mirath, which you explained, are impacted. So just
Yes.
a heads up, if you've actually named beneficiaries in your will specifically, that is something you need to be, you know, very, very vigilant of.
Absolutely. Distribution of the 1/3. So if you want to add, this is optional, by the way. You don't
Yep.
have to have it in your will, but, you know, again, highly recommend it. Think about that sadaqah jariyah that you want to include in your will. Ultimately, it's probably going to be that last time that you are fully in control of where your wealth goes once you pass away. And we also, dedicate a section to guardianship. So if you do have children under the age of 18, within a normal, I guess, relationship, obviously, if you are divorced or separated, certain, family law legislation provisions may take or override your will if they are challenged. But if you are in normal circumstances and an arrangement with your spouse, you have children under the age of 18, now is the time in your will to think about who it is that you would entrust to look after and raise your children, particularly if they have special needs, right? If there are children with special needs, there are certain things that you need to be very specific about, and it's your will that you'd be able to include in those instructions.
Well, that's a lot to cover, and for our listeners, that is quite overwhelming. But rest assured, we have a solution for you. So, alhamdulillah, inshallah, we'll come back to the solutions. Right now, we're just helping you understand, I guess, the layout of the land to be able to make an informed decision as to what things are going to look like after your death, to be able to pre-plan for that. And I think Islamically, there's no sort of point in having fear or apprehension about the topic and just leaving it up to chance. The more you're able to make informed decisions and take control while you're alive, the less of a headache in terms of time, costs, effort for your beloved ones upon your death.
Even just sorry, Tasnim, just to build on that, inconvenience for your loved ones, right? That, imagine you have left a very clear will instructions for them, rather than them have to sift through, potentially argue, fight about what you would have otherwise done. You're leaving a smooth process for them. And also, there was just a very important point that I wanted to raise, actually, completely passed my mind. That's fine. We'll move on to the next thing.
Inshallah, we'll come back to it. So Ramia, let's run the average person through what happens upon their death in terms of how their estate is distributed, so they have an idea of what it is that's actually distributed to the beneficiaries through wasiyah and mirath. So number one, when you talk about the word estate, what do you mean by estate? And number two, how is that estate actually distributed upon death?
Yeah. So a lot of people tell me, I don't own anything. What can I actually leave? Most of us carry, at the very least, phones worth at least, I would say, a few hundreds or 1,000 or whatever. You have jewelry.
I think the new iPhones are around 3,000.
There you go. Whether it's devices, land and property, obviously there's cars, personal property, designer labels that are otherwise worth quite a bit as well. Shares, businesses, cash in bank accounts, even debts that are owed to you by others are going to be considered as forming part of your estate. So everyone has something. And the way that we look at it is, when a person passes away, ultimately, we pull all these assets up by way of value, right? We work out what is the ultimate value when they are pulled up and put together, and that is what forms part of your estate. Now, the executor obviously has powers to decide as to whether it's a good time to sell, to rent, or if we're talking property, lease out the property if the market's not the best for selling, and ultimately distribute the rent instead of the actual sale proceeds. What you'd be shocked to Tasnim, subhanAllah, at the beginning of this year, I had clients that actually came to me, their sisters, 3 sisters. And I cannot believe that we live in this century, and this, 1400 years away from when the Islamic Inheritance Code came to grant females the right to inherit. These 3 sisters came to me that their father passed away 2 years ago, and their brother took control of absolutely everything. And they wanted to know, quote, if legally they are entitled to anything, because they know that under Islam they can't get anything. And I said, what do you mean? And they're like, yeah, because Islamically everything goes to the boy. And I said, absolutely not. Islam came to allow women to inherit something, right? So you'd be very surprised to know that there are a lot of people who don't know that the primary beneficiaries at the time of your death include parents, right? So if you have parents at the time of your death, they will always inherit, and it starts off from the 1/6, depending on circumstances and whether you are married and have children or not. Your spouse will have entitlement, and it does not matter whether you've been married to this spouse for 1 week or 20 years. The moment you are officially considered husband and wife, Islamically speaking, they have an entitlement under your estate or under your inheritance. Your children have entitlement under your estate. And in the absence of certain, genders as children, we will then be able to know whether or not your estate actually, as we call it, leaks out, perhaps to external parties such as uncles or aunts and so forth. So there's no one size fits all. It's very, very it's customized depending on who is alive at the time of drafting your will and then ultimately at the time of your death. But as a sort of baseline, children, spouses, and your parents will always inherit once you pass away.
Sorry, can I just jump in here before you continue with the rest of the distribution? For our listeners, we've taken out the guesswork for you in terms of figuring out if you died right now, Islamically, who would be entitled to inherit. Anyone who has done hifz or memorization knows that the ayat on inheritance are probably some of the most complex in the Quran. So if you actually go onto our website, MuslimWills.com.au, you can actually access the inheritance calculator absolutely free. So you're required to just log in, but accessing that calculator is absolutely free. And what I recommend people do is simulate scenarios in which, for example, if I died right now, who's alive, Islamically, what would they get? Have a feel for what the Islamic inheritance looks like. Then simulate, for example, if I died in 20 years' time, I anticipate, for example, my parents might not be alive. Therefore, who might get what, right? Now, obviously, no one can predict when you die or who will be alive at the time of your death. But I think getting a feel for the Islamic inheritance rule, which very, very, very considerably, as you mentioned, Ramia, depending on your living relatives, helps you make an informed decision about how to structure your wealth during your lifetime. So thank you for covering that, and please log on to our website and use that inheritance calculator. So Ramia, we've got the estate, we've figured out this is actual the assets, we've minus the liabilities, and you're left with a pool of money, right? What happens to that pool of money?
So again, first and foremost, debts and expenses. Should there be any debts and expenses, and especially debts incurred by the executor. So by the way, the executor is not required at all to sort of, take, responsibility for costs and expenses that they would otherwise incur when they come to distribute the estate. They have a legal right to deduct any costs and expenses from one's estate. Once all debts and expenses and everything is paid, by the way, if you have, this is another thing that people are not aware of, if you have actually allocated some sort of a payment or contribution bequest in that 1/3, that is the first thing that gets taken out after debts and expenses. It's not what's left over. So it's debts and expenses, then the 1/3 or whatever you've decided to take up out of the 1/3, then whatever is left is distributed between your primary beneficiaries. If there is, if your assets are only somewhat comprised of cash or savings and so forth, the same formula would apply. So whatever percentage you have allocated to each primary beneficiary in your will, that would apply to the cash or the savings that are there, and everyone will get their set share in accordance to your instructions.
Actually, while you were talking, the other thing that I thought about as to why people actually need a will, the average cost now of funerals is probably around the minimum 10K in terms of the plot and the logistics that goes into it, right? So I think even the average person might not necessarily have 10,000 lying around. So again, how do you take care of your beloved ones to ensure that upon your death, people aren't scrambling to try and meet just basic funeral costs? So if you outline that in the will, and the will, clarifies exactly your estate and the fact that, the funeral costs have to come out of that, again, that's another added pressure that your estate doesn't have to deal with that they would otherwise have to think about. So Ramia, thank you so much for that. I think we've got a good understanding now, I think, of how the systems work. And if anyone needs any further support or resources, our website has a lot of comprehensive articles and videos on everything from what is an executor, what is mirath, what is wasiya, all the topics that we just covered. We've got extensive resources on, so please jump on and have a look at that. Ramia, I just want to get into a little bit of the, I guess, thornier questions and issues that the average person wouldn't necessarily think about, but you have to deal with this by virtue of your expertise and being exposed to different family units and individuals. So I wanted to cover things that might make your everyday Sarah or Jane or Ahmed or John, what are things that make this person's estate complex, and what do they need to be thinking about? Because someone might not even know that they have this issue that needs to be dealt with, but we want to give them a heads up. So let's start with the first category, which is converts. I know you've already covered two very, very important things. Number one is that if you have non-Muslim family members, their assumption of what the what the distribution would be, and your values as a Muslim might not be coherent, number one. And number two, you've already covered the fact that in terms of how your body is dealt with at death, in terms of burial, and the observances around how the body is to be dealt with can be differing. What else do we need to think about for converts? I guess my primary question actually is, if you have non-Muslim family members, do they inherit? Do they not? How does it work? What do we do?
Yeah. So again, according to scholars in this on this topic, and again, misconception, people assume no, they're not Muslim, they don't get anything. They absolutely are, or not entitled necessarily, but they do have some opportunity to inherit. And the recommendation is that you do gift them and you do bequest part of your 1/3 to any non-Muslim family member. So say, for example, I'm a revert, I've just embraced Islam, my parents are non-Muslim. It's recommended to gift them from the 1/3 if you have the opportunity to, right? As for your 2/3, depending on your circumstances, if you are married into a Muslim family, your spouse is Muslim, you have Muslim children, they will inherit, and the standard primary shares and the apportionments will apply. If you don't have anyone whatsoever, I make this very clear, you need to seek specific fatwa for your circumstances. And that's what, one of the things that we do, having access to, whether it's scholars or imams who are well versed in this area of law. We all, normally, when it comes to very complex scenarios such as this, we recommend that a revert has some sort of a consultation with the imam and gets guidance, and then we actually stipulate or crystallize that advice by way of will, because your circumstances could be very, very, very unique and different. And I'm not I'm not a scholar. I have an understanding of Islamic inheritance, but these are very unique circumstances that would require you to seek fatwa potentially. So yes, your non-Muslim family members, be it parents or children, who have not embraced Islam, can and should, if possible, receive. Why do you think there's a recommendation, by the way, that we do gift non-Muslim family members? What's the...
Well, I think, is it to make their heart sort of closer to Islam and sort of build that bridge, I guess.
Yeah, to soften their hearts rather than, like ultimately, and Islam, when reverts embrace Islam, you are not expected and told to cut off your non-Muslim parents and completely, keep them out of your life and so forth. It's actually the opposite. So it's about winning their hearts and so forth. And even in the opposite, so for example, if I am a Muslim and my parents are non-Muslim and they have passed away, can I inherit from their estate? And again, the advice is, yes, you can inherit as long as you do not inherit more than 1/3 of what their estate actually stipulates. Now, you may ask, how would I know what the value of their estate is? Again, in the presence of a will, when you go through a probate process or apply for the grant of probate, you are legally required as the executor to provide estimates of the value of each asset that you are presenting to the courts on behalf of the deceased. So you would know what the value of the estate is based on that. In the absence of a will, it makes it very difficult, obviously, but you can seek appraisals and estimates of what the value of each asset is. So yeah, you can actually and absolutely inherit. The other issues we have are not just with reverts, Tass, it's also with new arrivals to Australia. I have a huge clientele that are arriving to Australia, new migrants and so forth, who are wanting to draft wills. and they are even stuck on the issue of who to appoint as the executor. Who to appoint as the executor. So I guess for new arrivals, I always ask, this is the time for as much as you possibly can to build relationships. I know it's hard and you have a lot to deal with, but build relationships with trusted people around you, be it someone at your local masjid, be it an imam. Yes, lawyers can be executors. I refuse to be, otherwise my full-time job will be just being people's executor. But this is, by the way, another gap in our community, and I have raised it actually with various peak organizations. We need to come up with some sort of a strategy that addresses this issue and maybe come up with a panel of trusted executors, if you want to call it that, whereby those from within that particular segment of the community are able to appoint as their trusted manager once their estate once they pass away.
It's interesting you raise that, because I think another one which I've been anecdotally hearing more of is also people who pass away and they actually have absolutely no living relatives.
Yeah.
So that's something you need to also, I think about and provide for. Now, the Islamic system, as you said, there's primary beneficiaries, secondary beneficiaries, and the third category is arham, like anyone where there's sort of kinship ties, and that can really spread Islamically. But also thinking about the scenario in which if you do pass away, there's absolutely no one who will get that. And I think this has come up in the chat. I'm just canvassing it, and it comes up often, is the issue of family or beneficiaries living overseas. Does your locality make a difference to your eligibility Islamically in terms of receiving an inheritance or receiving a bequest from somebody's inheritance, I should say?
Yeah, no. So again, but what I've seen happen, and what I do know people or clients actually do is if they are at an advantage of having assets overseas and assets here that are almost of and similar in value, what they do is they allow that asset to offset this asset when it comes to distribution, just for logistics and for ease. But just because, say, for example, your daughters or sons or parents live overseas, it does not somewhat exempt or waive their right, I guess, to inherit. They will still have entitlement, but it's now about logistics. If you do have assets that are almost of equal value, then absolutely, yes, you can offset those assets with whatever you have here.
The other thing we'll just mention before continuing, which is often raised, is I want to disinherit this person. I don't know, I don't like my brother, or I don't like, my child. He didn't attend, his sister's wedding. Islamically, how does that work? Can you just disinherit people because you don't like them?
Absolutely not. The only exclusionary aspect of removing or excluding a beneficiary from your will is if they contributed to your death, meaning they had they literally murdered you or killed you. Or if they have clearly and very outwardly claimed that they have left the fold of Islam, right? They no longer fall within the primary beneficiary category, but they could still fall within the 1/3 if you wish to gift them anything. So they're the only two general exclusionary options, I guess, or opportunities to have someone not inherit from you. But for any other reason, absolutely not. And just to build on this, Tasnim, the other issue is, and I get this particularly from adult children and at times elderly parents who say, for example, elderly parents have 4 children, 2 of whom are very, very financially well off and comfortable, 2 of whom are not. And they say, yes, we want to draft an Islamic will, but these 2 children have already told me that they've waived their right. They don't want the inheritance. So I say from an Islamic standpoint, you cannot actually obligate or even encourage or accept, I guess, that statement, because technically the right of inheritance is triggered once you pass away. You cannot ask one of your beneficiaries, even parents. So if right now, say for my parents, they're comfortable, they don't need that 1/6. And I've had a conversation with them by passing whereby they've somewhat said to me, we don't want your money. I cannot actually take that. from an Islamic standpoint. And as parents, you have to be very careful that you're not cornering and even pressuring your children at times to fall into that. So be very careful when it comes to having conversations with your beneficiaries, almost to under duress somewhat compel them or guilt trip them enough to sort of say, no, we don't want anything. But then circumstances change. When you pass away, their financial position may be very different. And also their right to your estate is actually prompted and triggered when you pass away, not during your lifetime. They're two very different things.
And I think this is really pertinent for people to be aware of, especially if they previously have engaged or are engaging a non-Muslim or someone who's not quite experienced in Islamic law to draft the will. Because obviously a solicitor is bound by your instructions and will go with what you're requesting to be put in the will. But Islamically, you still have an obligation to ensure that those instructions you give are compliant with the Sharia if you want to have a Sharia will. So Ramia, let's have a chat about some more complexities. There's something which you touched on earlier in relation to testamentary capacity and the case of the Turkish sister which passed away, Omar and Amari, which was challenged on the issue of testamentary capacity. What is testamentary capacity, A? And B, if there are issues with, for example, someone having mental health issues or someone being quite infirm or frail, cognitively speaking, due to health reasons, what happens in those scenarios?
Yeah. So generally speaking, and as a solicitor or legal practitioner, you are required to test one's mental state, I guess, when they come to give you instructions. So standard questions are asked, basic questions such as, what's your name? Where do you live? Trying to sort of gauge as to whether or not they have the ability to respond and they are somewhat composed in that response, right? Because you ultimately are going to be responsible for the validity of one's will when they pass away, should that capacity be questioned or challenged. That especially becomes an issue for what we call bedside wills. We get called often to clients who literally have either just about to enter surgery or have done surgery or are in almost palliative care at times and are expected to have their will drafted. I was called, it was a very uncomfortable situation because the last thing you want to be talking about amidst the final stages of anyone's life is how their estate's going to be distributed. And I was called to a bedside will last year where the children were literally talking to their father as to how it is and who owes you what, dad, and do you remember this? And he could even barely hold the pen at the time. So I said, I can't do this. It's just not going to work. I can't take instructions from this man because he does not have the capacity mentally and even physically to give me those instructions. So in those circumstances, I will not have ability to actually draft a will on behalf of the deceased. And more likely than not, they're going to pass without a will. Because what people don't realize, I had this question asked to me last week, my mother's got severe dementia. I'm her power of attorney. Can I draft a will? I said, absolutely not. As a power of attorney, it does not qualify you legally or authorize you to draft one's will or even alter or change one's will. Hence the importance of ensuring. And subhanAllah, when you think and reflect about things, as of 2020, we have literally been surrounded by death, right? Whether it's COVID, the various waves of COVID, then you had Gaza and Palestine. Death is constantly around us and it is not actually awoken or shaken us to ensure that we have our legal affairs in order once we pass away. So you need to make sure that you take the time to draft your will when your mind is healthy and sound, when you are not vulnerable, i.e., not about to go into surgery, you're not about to travel. Like, the worst are, again, I'm about to hop on a plane. Can you please just draft the will and I'll check it in transit. And if it's good to go, I'll organize for its signing. You're acting on impulse and vulnerability, right? So take the time to ensure that you are drafting your will when you are in the right state of mind, because ultimately, if you don't do that, A, it can be challenged, and B, more likely than not, if you lack capacity whatsoever, once you are assessed by, a qualified person, you're more likely going to pass away without having a will in place because you were unable to actually get it signed in the first place.
Does that also apply to someone who may have very complex mental health issues?
Yeah, so it's going to be very circumstantial, and at times we need to take into account whether there are court-appointed or tribunal-appointed guardianship orders in place. Are there any reports that have been issued by specialist doctors in those scenarios? If a person does not have capacity, like they are deemed as someone who fluctuates even in their decision-making process and so forth, then we may not be able to take those instructions, and it will just further complicate things. So we need to tread very carefully, I guess, and just reflect on the notion of when you have your health and that sound mind, to ensure that that is the time that I actually should have that very difficult conversation about death, and put things in order when, long before things get out of hand.
Yeah. Or I would also add to that, if you have people in your life who you love, start these conversations, because it's sort of, you are going to prevent them heartache down the track if this is not dealt with. And also, if you do have family members who have issues in relation to potentially testamentary capacity, I know one of the comments coming through in the chat is in relation to disabled siblings. It's really important that that advice is had, and you potentially didn't know this before this seminar, now you do. So these are things that we're sort of flagging as these are things that you need to get further advice and attention on, because your average simple estate solution is not going to cut it for these instances. As you mentioned, Ramia, there's a lot of discretion involved. There's a lot of it's a multifaceted effort, whether it's from medical professionals giving an opinion, a legal opinion. And the last thing you want, sometimes I think people think, oh, the process of going through that might be, a bit costly and time and effort. The cost of challenging an estate is going to be multifold. If I can ask everyone, please, to put your mics on mute. The cost of having that challenge is probably in the hundreds of thousands if this ends up in court, right? The sister that you said, the Turkish sister, the Amari versus Amari, that had national attention. The issue was, did she have testamentary capacity? And you said Sharia law was on trial, right? So please, these are things we need you guys to think about, inshallah. And as I said, we do have referral partners that we can refer you to if these are issues that you're thinking about or presenting with.
The other thing, sorry, building
Yeah.
on testamentary capacity, there's another side issue, and I see this particularly within the elderly clientele that we see, is the notion of duress or pressure, right? So I have seen time and time again, literally, one child take control of their mother or father's will.
Yeah.
They bring them in. Obviously, we need to sort of see the client by themselves, make sure that they're okay and they understand things. Then literally 3 or 4 months later, another child of that family has brought the mother in to change things. So we just also need to be aware that, again, when you are older in age, unfortunately, your vulnerability does kick in, right? Whether you like it or not.
Or even regardless of age status, some spouses, for example, if there's a power imbalance or DV situation where you're being asked to sign documents that you have no idea, it's really important to know, the capacity to be able to enter the will. The other thing which I'm going to get you to comment on, not because it's on this point specifically, but we keep getting it. Husbands and wives, they're so in love, they think one will is the solution to both of them. And we keep reminding them, you're independent human beings, you're independent Islamically and legally. So husbands and wife, different estates, different wills. Obviously, there's an interplay in terms of, for example, naming each other as executor and what have you. But in terms of testamentary capacity, just as a couple, you don't have shared testamentary capacity. You have individual testamentary capacity.
Absolutely.
All right, Ramia, let's have a chat about trusts, businesses, and companies, right? So this is something I wanted to clarify to a lot of our listeners, because when we were designing our product, one thing that we kept in mind was the difference between estate needs. So you may have someone who has a quite straightforward estate, and by straightforward, I mean they might have a car, they might have a house, or might not, and that's really the extent of their assets. Then you have people who have businesses, and that business can be, for example, through a partnership, it can be through a company. They might have a company in which they're a shareholder, they might be a director, they might just be receiving a wage. There's different sort of structures that go into play. And then you have the issue of trusts. So whether as a beneficiary of the trusts or a manager or what have you, just talk us through just very briefly third-party assets and entities and why someone who may have a trust business or company may need to see a lawyer to be able to deal with their estate. And why, for example, when we tell them, you know, our product is not for you, can you please go see a referral partner? Can you just sort of paint that landscape for us in terms of what goes on when you've got things like trust businesses and companies?
The Muslim community, alhamdulillah, is evolving. We're getting wealthier, we're getting more innovative, we're growing, right? And that's a good sign. So as you said, Tasneem, it's not your standard, you know, husband, wife, buy that one property, maybe a side investment property. We're talking multifaceted types of, different types of layers of assets. So whether it's also buying property in trusts, what people don't realize also is that trusts don't actually automatically form or are not captured as part of your estate. You have a trust deed that would ultimately dictate how it is that your that your asset that is held within that trust is going to be distributed. You can absolutely refer to it. And we always ask clients those questions because, believe it or not, especially between some spouse relationships, the wife knows nothing about the husband and vice versa. So we do at least ask, do you own any assets held in trusts? Or entities, and can you at least disclose them? Because, you know, at least when you do pass away, we know where to go and what to, you know, sort of put together and help sort of compile as forming part of your estate. So there are trusts, businesses are an issue. I have noted or noticed within businesses and companies that are owned or held within many people within our community. Unfortunately, they don't have the right documents that fall or that sort of complement a will structure should something go wrong. So for example, if you are in a business partnership, there is no such thing as I trust my partner with my life, you know, he or she are going to know what to do. You need to have a partnership agreement in place. You need to have the right paperwork in order to ensure that in moments or times of death, for example, specifically, not just separation or dissolving of the business arrangement during your life, but even in death, what the priority is, who gets first priority when it comes to purchase of the business, for example, and of shares and so forth. And then you can reflect those instructions in the will, but partnership agreements are very important and they're often overlooked. With entities that you may hold within certain structures or assets that are held within entities and you have shareholders, you need to have a shareholders agreement. They're very important in terms of, again, not just the dissolving of that entity during one's life, but in the event of death, what's the sequence of events that you all agree to in terms of continuing or the continuation of that business or that entity. So I'll give you an example. You know, say I've got a business arrangement with a really amazing partner, he or she are great and we're doing well. And then suddenly I pass away and suddenly members from my family have taken over my portion to continue running that business. And that's a disaster because A, they know nothing about the business, B, they don't have the expertise or abilities, and they've just completely run the business down, as opposed to, for example, having the right paperwork that complement your instructions in the will to ensure that your business partner will either have an arrangement to potentially buy you out or take control of the operation side of the business to ensure that the business is not going to fail or fall apart in your absence, and the list goes on. So it's not always just about having a fallout, you know, or whatnot, but it's more about ensuring that just because you have passed or you're no longer there, the ship needs to keep sailing, right? You need to make sure that you have a contingency or sustainability plan or succession plan that things will carry on whether you are around or not around, and there is the least disruption involved when it comes to, you know, the operation side of those particular entities.
So in a nutshell, if you are engaged in whatever capacity in any structure that's a third-party structure, other than your very person of your own being, there can be documents that are required for the continuity of those interests or benefits. And a will in and of itself might not necessarily be enough to cover that. So it's really important that for the purposes of succession planning and ensuring continuity, that those documents are looked at. So in a nutshell, that's why we always say if it's a bit more complex, you need to get legal advice, because just a simple document, a will, won't cover those interests.
Yeah, and there are
Ramia,
also tax implications, Tasnim, sorry, that will apply, right? So this is where, we, for example, engaged with accountants when it comes to structure or restructuring certain things and so forth, to make sure that there are also no tax liabilities and implications when it comes to your passing, and making sure that, whatever structure we have formed or come up with will ultimately minimize that liability, rather than have your estate liable for X amount of dollars to tax for no reason.
And this is something I think we see, especially in some of the older generation, where they had, for example, thriving multiple businesses. But then, for example, say the asset, such as the family home, was actually held in the business name. If these things aren't investigated and looked at, you're literally looking down, a barrel, waiting to combust at the time of death, because the way tax law is going to deal with this, succession law, business law, it's an intermingling of the systems. And the last thing you want, for example, is, your 89-year-old mother not being able to live in her own home, which your father potentially purchased through a business structure 50, 60 years ago, right? So if you are involved as a director, as a shareholder, as a beneficiary of trusts, businesses, and companies, it's really, really important that you do get legal advice. And we do have referral partners, inshallah, that we can refer you to get that. Ramia, let's have a chat about children. We sort of briefly touched upon this when you were talking about special needs. And you specifically also mentioned the issue of children when we were talking about guardian at the beginning, in terms of what goes into, components of a will. What are other things that people need to sort of think about in terms of providing for their children? And this is sort of almost to my next point, which is also the issue of lifetime gifts, right? So Islamically, what can I actually do? What are the parameters of what I can do during my life to be able to provide for certain people? And with children specifically, what are things I need to think about outside the traditional will to be able to provide for my children, their care, their upbringing, a certain quality of life for them through estate planning?
Yeah. So again, this question is especially relevant to clients that come through and say, I have 2 daughters and 2 sons, and I want to give my daughters an equal share to my sons because they do more than what my sons would otherwise ever do for us. And I say, well, that's no longer an Islamic will. However, you can give what we call a hiba, a gift, right, during your lifetime. But subhanAllah, humans are very greedy, right? Because they want to hold on and maintain control of absolutely everything they have to death, literally, and then benefit their children in however way they wish to do so. The argument then is no, but if I give them during my lifetime, that then opens up another can of worms. What if they go through divorce? What if they go through, this? I said, well, you can't have both, right? You need to make that decision. But generally speaking, gifting, and there are certain conditions placed upon this, by the way. You cannot gift, and scholars talk about this from an Islamic standpoint. If you're on your deathbed, you cannot, it's too late. Like you have been told, that's it. You've got a set number of days, months, weeks left. You cannot now gift, right? Because it can be then on I guess almost the line, or it may overlap on what may form as part of your estate by way of inheritance. So you have to be there has to be certain conditions that are met when we're talking about hiba or gifts during your lifetime. So you can't be on your deathbed. Generally speaking, you are at liberty and free to gift and give from whatever you own during your lifetime, however you please, to any of your children, technically, right? So for example, I own several properties. I know that I've only got 1 daughter and 5 sons. I know that my daughter is only going to get X amount. So you know what? I'm going to gift her during my lifetime. That is absolutely okay. But the issues around this, and if you listen to he's a renowned Syrian scholar, Sheikh Ratib al-Nabulsi, he talks about this, this notion of jealousy and envy, and creating notions of jealousy and envy within siblings. You need to think about and reflect on what this will come to do in your absence, right? So if I'm gifting one child, even though you from your perspective can see that it is just and equitable, the other siblings may not actually see it as that. And are you, in fact, you're not doing anything haram or prohibited, but you are otherwise potentially prompting or causing a spark of jealousy and envy. And then you are defeating the ultimate goal that you want when you pass away, and that is unity and harmony between your children. So you need to be conscious. If there are tensions between the siblings and you are doing these things behind the scenes, it's not going to be in anyone's favor. But if you see that there is generally harmony and there's an understanding between the children, and your daughter genuinely, is loved and respected, and she deserves what she deserves, absolutely no harm, especially when it comes to, for example, gifting gold during your lifetime, gifting by way of, money or cash. Property is big, so you have to be very cautious, because ultimately you need to be very mindful of whether you're intending, if your intention is to strip away your beneficiaries from what they could otherwise receive. If that's your intention, I want to hurt my other beneficiaries because, they don't deserve it. And that is your intention for why you are disposing of your assets during your lifetime, then Islamically speaking, that can also be problematic. So gifts are absolutely fine.
Sorry to cut you off. This is the point where we parked earlier. And given that you're on it, let's delve in to this. So you were talking about earlier the difference between joint tenancies and tenancies in common. So where the spouse receives a share versus when a spouse doesn't receive. So can you just run us through, because I think the average listener may potentially have a situation where they have a joint tenancy situation. What happens to a joint tenancy situation in terms of estate distribution, A? B, Islamically, you said that there were some issues with it at the outset, which I said we'll come back to. And C, if someone wants to, for example, give, their spouse the security of having a home to live in, but at the same time, not deprive their eligible compulsory beneficiaries of a benefit, what are things that they can think about, such as, life tenancies and other legal ways of dealing with their estate while they're alive and conscious, to be able to prevent some of those issues? Because I think this is something that the average person, especially if they're a homeowner, will encounter. So just run us through that, inshallah.
Yeah. And again, each scenario needs to be customized to your own circumstances. So for example, let's just assume you only have that one property. Your entire estate is centered around the one family home that you and your spouse live in, and you have bought it under a joint tenancy arrangement. Joint tenancy basically means that you both own it 100% together. It cannot be split or separated. So when one person dies, the surviving person receives it in its entirety. By the way, and just a complete side note, never ever buy a property in a joint tenancy arrangement with a non-spouse, as in your brother, your sister, your friend, your business partner, because it's going to pose as being problematic. You cannot leave it in your wills, right? You are completely stripping your rights away from ensuring that you are able to leave it in your will. So the joint tenancy arrangement, generally speaking, is adopted between spouses when they come to purchase a property. The more Islamic, and this is a very convenient arrangement, by the way, because like I said, if you pass away, it's simple. You don't have to go through the probate process. It's just lodging the notice of death and a death certificate with the Land Registry Services. Costs a few $100s, you're done. It's now transferred into the surviving spouse. It only becomes problematic, generally speaking, when, as I've said, if it's a subsequent relationship, meaning this is a second marriage, the biological mother of the beneficiaries is not around, and this is not the biological parent. And also in the event that that surviving partner suddenly remarries. When they remarry, it is also going to trigger another spilling over of potential inheritance to that spouse, right? So that's the Islamic complexity and dilemma that would arise with a joint tenancy. The more Islamic ownership arrangement is a tenant in common arrangement. And what that means is you are literally a clear 50% owner and a 50% owner, right, of a certain property. It can even be 75 and 25. And I've seen those with very stringent, I guess, religious understanding of how things work. say I have worked as a wife and I've only contributed 20% into the purchase of this property, then that's the percentage that I reflect on that property. And then 80% is recorded as the husband. And that's very fair. The only issue, again, subhanAllah, there are issues that do arise all the time. Yes, I can include that in my will, my individual will, but say it's the only asset and there's no other asset. The spouse passes away, the husband passes away, I'm the surviving partner, and I have adult children who suddenly want their shares. Am I expected to sell the asset and end up in the street in order to give everyone their shares? That's the dilemma. We've sought counsel on this from various religious scholars here who are, again, religious scholars who are familiar with the system here. You can't ask a religious scholar about these ownership arrangements that lives in Saudi Arabia, by the way, because they don't have the context. It's very different, right? From a fiqh of priorities perspective, if this is your only asset, and particularly if we're talking an elderly spouse who is unlikely to remarry, the priority and the recommendation is to allow that surviving spouse to remain living in the asset and allow them what we call, if they haven't been given that by way of a will as a life tenancy, to allow them to remain living in the property as a life tenant rent-free, right? That would be better for them. Now, if you want to secure that for your spouse because you have fears that they may actually be thrown out or evicted, then the recommendation is that you actually stipulate that in your will and you grant the surviving spouse a life tenancy, but subject to conditions, because this is often overlooked. And the conditions are that should that surviving spouse remarry, that should automatically trigger distribution of the estate, because then it becomes diluted. And there is a risk of having your children's haq and rights spill over to third parties, which are otherwise, what we call potentially gold diggers who have come into the picture.
Yeah. And just to clarify for those listening, if this is something you are wanting to consider in terms of life tenancies or other legal mechanisms to be able to estate manage your affairs during your lifetime, this is something you definitely need to be seeing a lawyer for. It's not something where you can just write it as a one wish, a line wish in the, it won't hold effect.
If you currently have properties as a joint tenancy arrangement, it can be severed now. So again, lawyers are equipped to sever those tenancies. If they are 50-50, we can split, and there's no stamp duty implications on that. It's only registration fees with the Land Registry Services. So that can actually be repaired and amended, right? By the way, there was a comment in there, and I believe it's from an accountant. I have to just, note it. Yes, if you do gift real property during your lifetime to children, it will definitely trigger stamp duty, 100%. So just be cautious of that. And that's another deterrent, unfortunately, by many of our clients that we advise to do that. We have to seek evaluation for stamp duty purposes. That is a legal requirement. And we have to pay stamp duty on the value that is actually noted in the report. So we can't just put a lower figure for the sake of it. You will pay stamp duty on the value that is presented by a qualified stamp duty valuer.
And there's also obviously capital gains. So if you are interested in the area, please have a chat to your lawyer and accountant. It's a can of worms, but it's something you need to be aware of. Just before we wrap up this point, I think for males, think about if you are the sole owner of a property or you and your spouse are joint owners, the Islamic inheritance implications of that. For females, if you are a joint tenant or you're not on title, think about the Islamic implications that for you practically in terms of being able to continue living somewhere. But also if you are a joint tenant, which means that the estate passes to your surviving spouse, if you want to, for example, provide for your sister who Islamically isn't a primary beneficiary, that's something you need to be aware of if your whole estate is, for example, tied up in a joint tenancy situation. So if these are questions of importance to you, please use the calculator, get a bit of an idea and seek further advice if you need to. I am conscious of the time. Let's quickly have a wrap-up conversation, Ramia, in terms of superannuation and insurances. What does the law say about that? Are they included or not? I'll quickly take you guys through the MuslimWills platform and then we'll open it to Q&A inshallah. So Ramia, superannuation and insurance, is it included? Is it not? How does it work?
So superannuation generally is almost like trusts, so it's not specifically captured in parts or as part of your estate or will. However, and I know everyone panics when we say this, it's good to go back and cross-check the nature of your trust, or sorry, your super or your policy. It is always recommended to have a binding nomination as the preferred option. And what that means, generally speaking, when it comes to distribution, your trustee is going to be bound to distribute the superannuation in accordance to the will instructions. So it won't just go to one nominated beneficiary, as you may have noted. And if you're okay and you trust that that beneficiary will execute in accordance to the Islamic requirements, that's fine. But the recommendation is have it noted as a binding nomination, and that way they are bound by your instructions in the will. Insurances, are we talking life insurance here specifically, Tass?
Yeah, so life or income protection. So obviously insurance is where there's benefits at death. Now, again, not addressing the Islamic component of halal or haram, because that's something that people obviously need to be aware of. But how do the benefits come into the estate if you want them to come into the estate?
Yeah. So generally speaking, again, insurances or particularly life insurance is triggered after the fact, right? So it's not something that at times we've had scenarios where we've gone through probate, we've finalized it, and then insurance comes to a decision that actually there is a payout and so forth. The recommendation again is to, if you do have insurance that has been taken out, to make note of it and note it in your will, because a lot of executors and beneficiaries of estates are unaware that the deceased actually had insurances in place, and have an instruction specifically in their noting that the insurance payout, and it can be significant. I had a client who had a $450,000 life insurance payout made out to her. So it's quite significant. Have a note in there or an instruction to ensure that it is distributed in accordance to the instructions of your will.
Jazakallah khair. Awesome. Thank you so much, Rami. We've covered so much, and I know there's so many questions that come from each point, and we can really spend an hour on each. But for the sake of time, let's just continue. So what we have is MuslimWills, which is a platform developed by Awqaf Australia, gives you a solution to a simple estate. So if you have a simple estate, and we've already covered in detail what we refer to as a simple estate, if you head over to muslimwills.com.au, you'll be able to have a suite of resources available to you to help you with estate planning. Number one is we have a whole bunch of resources collated by Islamic as well as legal professionals on aspects of legal and Islamic inheritance law. These are absolutely free, and you're welcome to use them and refer to them. Number two is we have an inheritance calculator, which allows you to sort of, take the guesswork out of Islamically who's entitled to inherit. And we always recommend for people, before using our product, before seeing a lawyer, do the inheritance calculator so you can get a feel for Islamically who would inherit from you. So that way you're about your estate planning. So you're making informed decisions about your estate planning and who to leave, for example, wasiyah and things like that too. That's number two. Number three is for the price of $99 plus GST, we actually give you a step-by-step guide which will allow you to create a legally valid will. That covers the requirements that Rami has gone through if you have a simple estate. And the fourth thing, which we're quite excited about, and I think is sort of really unparalleled, is we give you the option of what we call a secure vault, which is attached to your will. That secure vault is your opportunity to keep a live list of your assets and liabilities, family members, their contact details, life insurances, your super, all the documents that form a part of the suite of your estate and financial planning. So that way at death, your executor literally has a one-stop depository of your documents, right? And this is really, really important so people aren't left scrambling for, what assets do they actually have? Oh, is there a cousin overseas? What's a number for, the person in the village, right? It's your online vault where you're able to actually secure that information, or if you want sentimental items like letters to your loved ones or what have you. Now, how is MuslimWills different to other products? Number one is we take you through screening questions to ensure you're eligible. So things like testamentary capacity we cover, things like language difficulties, things
Building बन गया साला
like
मैं
having complex estates
थोड़ा
and things
थोड़ा
like
अब
that.
तक प्रॉपर्ली काम नहीं पीपल अब तक
Can I
भेजा
ask everyone to please go on
आप
mute?
तक सेट करते रहे
It's a guided wheel builder. It's not just a form, so it's very, very different to what you'd pick up, for example, say from the post office or what have you. It has specific guidance and questions for converts, which Ramia touched on. So what happens in the event that you pass away and you have no surviving Muslim relatives? What happens if you have some Muslim relatives and others that are not? We've got wording for superannuation and insurance providers if you want those benefits to come part of your estate. We've got a comprehensive list of end-of-life wishes and directions relating to prep, ghusl, funeral, and burial according to the Islamic requirements. The guesswork is taken out for you. What you need to put in is personal preferences. So, for example, I want a particular masjid or I want a particular sheikh, things like that. We have a comprehensive guide for execution to make sure that you're signing it properly. A comprehensive guide for people with English difficulties, so translators, certificate, and what have you. And finally, an automated function for executor nominations. Now, the last thing which I think our product is offering users, which is quite unparalleled, is exactly what Ramia was talking about earlier, which is the question of legacy. So Allah subhanahu wa ta'ala has given us this amazing avenue to ensure that we are able to continue good deeds after our death through the hadith of the Prophet ﷺ. When a man dies, his good deeds come to an end except three: ongoing charity, beneficial knowledge, and a righteous child who pray for him. Ongoing charity or sadaqah jariyah is what we want to hone in on, because that's the aspect where you have agency, you have control during your lifetime, and you can actually plan for your legacy. Beneficial knowledge might be something that some people have and others don't. And righteous children, may Allah subhanahu wa ta'ala grant us all righteous children, that can also be sort of, a hit and miss depending on whether you might or might not have children, and also depending on what they choose to do. So ongoing charity is your avenue to be able to actively invest in your legacy, and to have a life filled with purpose that continues to keep giving after your death. What makes Waqf different from normal charity, what makes it ongoing, is the perpetuity element. Perpetuity meaning it goes on and on and on. It doesn't stop at a particular point. And what the Awqaf platform allows you to do is when you make a donation to a specific charitable cause of your choosing, that donation is invested. The returns from that donation are split. A portion is reinvested and a portion is divested to charitable purposes of your choosing. And that Waqf continues to grow and grow and grow. Okay, so you might start off with a sadaqah jariyah of $10,000. In 50 to 100 years' time, the value of that particular charity might be in the hundreds, if not millions, depending on how that's invested and looked at. The revolutionary product that Awqaf Australia is offering is that you're able to invest in Waqf from as little as $1. There's no minimum amount for contribution. And there are charitable causes that are tax deductible if you're interested. So you are also able to have this Waqf framework as a part of your will in that 1/3 wasiyah component, which Ramia touched on. So if that's something you're interested in doing, the Wills product and Awqaf Australia, inshallah, will be able to partner with you on that. And if you do need any sort of further guidance, please feel free to touch base. Now, Ramia, we've got some really good questions in the comment section. So what I'll do is, for the purposes of everybody, let me just read them out, and then I'll get your thoughts on it. Okay.
Where do you start?
All right. So if my life insurance is 1 million and my wife is the sole beneficiary, once she gets the 1 million after I die, does this amount belong fully to her, or this amount also considered to be a part of my estate that's to be distributed as a part of my estate?
Well, again, from a legal standpoint, if you've made no accommodation for it in your instructions within your will and so forth, yes, she is the legal beneficiary. She will get it. If you've made a accommodation or reference to it and you want to make sure that it is distributed in accordance to the instructions of your will, you have to make reference to it, specifically speaking.
Okay. With the discretionary portion of wasiyah, the third, can it still go to a main beneficiary with the consent of all other compulsory beneficiaries?
The standard answer is no. That's the standard answer. But if there are circumstances, so for example, let's say they have special needs, and there is an appointed trustee and guardian and so forth that may need to oversee the expenditure on that particular beneficiary, I recommend that you get a specific fatwa on that on this particular question, because it's not a common question, right? Generally speaking, the baseline answer is no. The primary beneficiary does not get any entitlement from the 1/3 wasiyah.
Okay. It's interesting because we've also sought an opinion on this from Professor Munir from South Africa, who helped us draft this platform. And I guess there is also another opinion that with the consent of other beneficiaries that is possible. So the recommendation is please get some further advice on this Islamically, because it can really make or break how the will is drafted. The next question is, our house is in my and my wife's name. So the contract states that we are 50% owners. Well, I'll dispute that because the contract wouldn't say that. It'd either say you're joint tenants or tenants in common. But in reality, I'm the only one who paid for it, and she has not paid anything towards a home. So does that mean that when I die, she needs to sell the house and distribute 50% of the house value as a part of my inheritance?
Well, again, it depends on whether it's a joint tenancy or tenancy in common arrangement. If she's a joint tenant, if we're talking legally speaking, she will get the whole property, right? That's from a legal standpoint. If she is a tenant in common and you have made reference to your share in that property in your will, technically speaking, you know, she may, if you haven't accounted for a potential life tenancy for her, and I've seen these scenarios where unfortunately beneficiaries have interpreted the will literally, that have not made reference to any life tenancy, and required the mother or the surviving father to sell the property so that they can actually redeem their 50% share. So you need to make reference to it if you don't want that to happen.
Okay. What are the approximate total costs to write a will? So we mentioned the MuslimWills. If you have a simple estate, it's $99 plus GST. Ramia, with a will generally through a lawyer, obviously if you have, you know, a multi asset structure, it's very, very different from if you just have something straightforward. But generally, as a ballpark figure, what would people be looking at if they are getting a will drafted through a solicitor?
Again, depending on obviously how simple or complex, I'm going to give you a range and say anywhere from $350 to approximately $1,000.
Yeah.
Just
Okay.
depending on how complex.
And obviously, the more structures require other documents like the succession planning documents, they're different instruments that you have to think about. Thank you. Ramia, is there a way to register the will in Australia? I'm gonna the questioner asked in Victoria, but number one, is there a requirement for will registration generally? And number two is with whom or where should the will be kept?
Yeah. So look, I highly recommend that in the presence of actual executor or family members that you have, there's no need to register the will. Usually would register it with the public trustee of whatever relevant state. I highly recommend you don't, because generally speaking, every time, firstly, there's administration costs. Secondly, there are, or fees. Secondly, every time you want to make a change to that will, there is going to be a lengthier process and fees involved. Now, if you are someone who has absolutely nobody, and you've in fact appointed the relevant public trustee of that state, then yes, you will have no choice but to register it. Bear in mind also, lawyers can hold copies or retain copies in custody or, you know, by way of safekeeping at certain costs or fees. Otherwise, you are best to hold the original copy and keep it in a safe place, and we recommend that you give your executor a copy of your will. If you trust them that well to actually appoint them as executor, technically you should be comfortable enough to give them a copy of your will during your lifetime should you pass away.
And just on that point, I think if it wasn't made abundantly clear to those listening, a will is actually legally considered the physical hard will that's physically signed with a pen in the presence of two witnesses in person. For those thinking that due to DocuSign and the electronic age, you could just have a document that's emailed around and signed, and then you've got the electronic copy, that won't hold up. Even our will document, what we give you is a template which is required, you know, based on how you draft it, that needs to be physically printed, physically signed, and physically kept, and that's the actual will. So scans and copies and electronic signatures and stuff, it's a whole nightmare. So please be aware of that. Ramia, I think you've answered this, but let's just make it abundantly clear again for the record. If a father is still alive, can he divide his inheritance while he's still alive? Or is it considered a gift to his children? Or is inheritance only considered once he's dead?
Inheritance is triggered once a person passes away. Anything that is given, because we get this question a lot. I wanna distribute my inheritance, literally quote while I'm alive. That's not inheritance. That's now gift. That's hiba. It's completely different. Your inheritance and what forms part of your estate is whatever you are left with as of the time of your death. And the entitled beneficiaries are the people that are going to be present as of the time of your death. If a beneficiary passed away literally, a few days before, they are no longer a beneficiary, technically speaking. And there are other rules that would apply in those circumstances. So it's whatever wealth you have at the time of your death, and whatever beneficiaries, whoever is a present or alive at the time of your death, they're the ones that benefit from your estate.
When one of the parents are deceased, either the father or mother, since the property is a part of the estate, how is the inheritance law applicable to the property? Does this need to be sold off?
I don't understand.
Me neither.
Yeah.
If Mohammed, can you please rephrase your question in the question box, because it's hard to understand. Okay, this is interesting. Islamically, is the will same for women and men? Specifically, if we say that a woman will have certain assets, etc., pass away versus a male who passes with his will?
Well, every individual needs their own will. Every single individual requires their own wasiya as well, right? So whatever you own as a female, like I know, for example, an asset for a female could be gold, right? That would form part of her estate and it's hers. Whatever is considered and deemed hers will form part of her estate. Whatever is considered and deemed as his is his. It's the complexities around joint property and joint bank accounts that may pose as a bit of an issue, right? And I think this is a lengthy conversation, but if there are those things that are present, it's very important that you have these discussions, particularly with lawyers, because at times they can be a bit problematic.
Yeah. If I have assets overseas, does my Australian will cover assets overseas, or do I need to create another will in the country which has the assets to deal with?
Your will is generally jurisdictional to Australia, and specifically more so, even though it is tailored to adhere to all states, it is relevant to whatever state you are in, generally speaking. The will, we cannot guarantee as Australian lawyers that your will actually be applicable in another jurisdiction. And from experience, I had a client who had assets here, and in the UK, they actually needed a will in the UK for assets there. So generally speaking, we say, and look, if you are someone who comes from a country or region that has, Sharia law as the applicable law, generally speaking, you probably don't even need a will, unless you want to stipulate a wasiya within those instructions. But the law of the land there would apply the Sharia anyway.
What are the requirements for listing minors as beneficiaries in the will?
What do we mean by that question? Sorry.
FS, if you could please clarify what you mean by that.
Yeah.
I'm assuming, so let's just answer, assuming A, if you have children, obviously they're minors, and they are your Islamic beneficiaries, you can just list them by name.
Yeah.
I guess if you wanted to provide for them in a non-straightforward structure, for example, such as a trust, is that covered through the will, or is that another process?
Yeah. No, we can cover them, by way of trust. And also we would appoint, obviously, because if they're minors and underage and they have entitlement, they're not, if they're 12 years old, they're not going to take, say, their $50,000 of inheritance and spend it. We would cap it and include conditions, for example, that they access it at a certain age or after certain events, say if they get married and so forth. And we would appoint a nominated trustee to oversee the spending requirement or expenditure and maintenance of that child. and the guardian to look after their day-to-day, you know, care, I guess, and upbringing. So trustee and guardian can be two different people, or it can actually be the same person.
This is it. The question just says, how about properties that you bought when you were still single? So I'm assuming this is in relation to what's included in the estate. So does it make a difference when you purchase the property, or it's just what the title of the property says?
Doesn't matter. If you pass away and you bought property 50 years ago and you're suddenly married, that will form part of your estate. And we're talking Islamically, especially speaking, your beneficiaries will have entitlement to that. You may be confusing it with divorce, because that's a completely separate thing. You may have had prenups involved and so forth, but death doesn't matter. If you bought it now or before you met your spouse, it now forms part of your estate once you pass away.
This is a common question. So if the beneficiaries live overseas, how do you distribute or disperse their portion to them?
Yeah, so you would have appointed an executor. We always recommend your executor is here in Australia for logistics reasons. Once they have been granted probate and they are now at liberty to execute and distribute the estate, you know, you would have, I mean, we literally this morning, I had to transfer, we administered an estate for a beneficiary, for an executor, and one of the beneficiaries was overseas. So the funds were in our trust account. We had to transfer the funds by way of bank transfer to the international bank account of that beneficiary. So you have to find a way, whether it's bank transfer or Western Union or whatever it is, to dispose of that particular you know, asset to the
Yeah.
beneficiary.
And off the back of that, and tied into what you said earlier about, for example, if the overseas assets are of equal value to the Australian property, and there's the offsetting, the question is, but if the value is not similar, which is often the reality, what happens?
Well, the best thing to do is again, you would need to value assets here, value assets there. If you feel like you wish to pull them all together in terms of value, right? In terms of value, and then sell and distribute accordingly. So if you feel like you cannot offset, the best thing to do is just to pull the values overall together and then distribute accordingly. And don't forget, there are always not complexities, but there are different sort of ways in which assets are distributed when it comes to post probate. For example, if there's a family home that, you know, someone or one of the beneficiaries really wants, they don't want the home to be sold, there can be a mutual arrangement whereby a valuation is sought and they buy the property and pay out each of their siblings or beneficiary the relevant share that they would have otherwise received. There's no haram or prohibition in that, as long as, generally speaking, there is a mutual agreement and everyone's getting their share that they would have otherwise gotten should that property have been sold to a third party.
Okay. If one of my siblings has learning disabilities, is unable to manage her own finances, does this sibling also inherit?
Well, the question is do they have a legal guardian that's been appointed here and a financial manager that's been sought by the tribunal? If that's the case, then technically speaking, I would say, just based on, you know, the very brief facts that we have, that they probably will not be able to. And hence, they will probably need a permanent trustee of some sort to manage their contribution or their share that they would otherwise have received. I don't think, if again, someone is managing it during their lifetime, then more likely than not, if they do receive a share, that share should also probably be managed as well.
And I think, I mean, not noted in this, but just a heads up for listeners, if you have situations where, for example, one of your potential beneficiaries is bankrupt or has issues in terms of solvency, that can also create issues in terms of them being able to receive funds. So that's something you need to look at and seek legal advice on.
But it's not just that. Like I have clients with beneficiaries who have, you know, other forms of, for example, addictions, whether it's gambling, whether it's drugs and so forth, and they're not in a you know, state of mind or ability to handle wealth. Hence, the deceased or the testator would otherwise have instructions in there that there's a permanent trustee that's appointed and that incrementally gives them, you know, if you want to call it pocket money, to spend over the span of their lifetime. And if they wish to challenge that arrangement post-death, then they can.
That's a really interesting point you make. So I think what people need to be aware of is there's a difference between disinheriting someone and Islamically the prohibition on that. But there can be ways of managing that inheritance to ensure that the benefit is received adequately, whether by virtue of that person being a minor or whether that person having complexities such as, bankruptcy, addiction issues, or what have you. Can an executor also be nominated as a beneficiary in a will?
100%, yes. So, for example, I have parents, they trust me, they trust my brother, who's also an adult. They would appoint us both as their executors. And we recommend that actually, if you have a good trusting relationship with adult children, it's better that they manage the estate than an outsider. So there's absolutely no harm in that at all.
Can a property that is owned under joint tenancy, such as a family home or investment, be changed to tenants in common? And
Yes,
does
we
this
can
cost
sever.
more stamp duty to change?
No. So if both names are already on title and we are literally just severing the joint tenancy to a tenancy in common, it does not trigger stamp duty. No.
Can you purchase a property with a child as joint tenancy, and this will go to child outside of the will upon your death?
That's what will happen. Yes. If you pass away, it will automatically go to that child, bearing in mind though that there are other strings that may be attached to that later. So if they marry, they divorce, it forms as part of their asset pool. So they're a bit, just be very cautious of that as well.
There's also a comment here in relation to your comment about newly arrived migrants. There can be tax implications for having beneficiaries or executors as non-residents. So it's important to get tax advice. So thank you for that comment, and please see your accountant in relation to that. For joint business owners, both directors, how do we include this in our will?
So again, shareholders agreements or partnership agreements are very important because generally speaking, they talk about or they would stipulate conditions around whether the partnership or, entity dissolves, or in the event that a director or / partner passes away. And then you would reflect those instructions in your will or make reference to it, right? So these side agreements are very important. They're like the trust deed also. So if you have a trust, you would have a trust deed that will ultimately talk about how it is that that particular asset is to be distributed or dealt with. And the same goes for businesses as well as entities or companies held.
The next question is, I'm a divorced lady whose father has also passed. My 3 children are adult age, but on a disability. What I want to know is my share of inheritance still 1 part to 2 part of my brother's? I think there's a confusion here because there's a difference, and I think, Ramia, you noted this very clearly. There's a difference between what you're inheriting from your own father and what you're passing on as the parent.
Yeah.
So I think what Ramia already clarified is what you're receiving from your own parent Islamically is different to what you inherit to your children.
Of course. Because
So
the primary beneficiaries for your parents is going to look different to what your primary beneficiaries are going to be, right? So yeah, they're 2 completely different scenarios.
all right, I'm conscious of time, so I'm just going to do probably just a few more minutes for the next 2 minutes. And I appreciate your time, Ramia, and everyone's patience. Where the children are under 18 at the time of death of the parent, what is the best way to keep the asset or money in trust without great tax liabilities incurred?
So I would ensure that the assets, depending on the nature of the assets, so the trustee or the executor can actually hold the particular assets on trust until the beneficiaries reach such an age. And generally speaking, I recommend there's no legal requirement, but the recommended age of maturity, hopefully, I say is anywhere from 21 to 24, or if they get married, right? So we always have that clause. Because you don't want to also restrict your beneficiaries. Say, for example, they're mature and they're capable enough to get married, they should have access to that particular asset. But ultimately, the executor can hold the asset on trust, and whatever income is generated from that asset would need to go into an estate account that is going to potentially be distributed in accordance to whatever instructions you have. But setting up trusts here might be beneficial, and you might need to have a chat to your accountant to minimize potential tax implications in that scenario as well.
Yeah. Ramia, this is something we get a lot of inquiries on. Can a guardian for the children be an overseas nominated guardian?
Unfortunately, look, the standard answer is it's better if they're not, but I understand 100% that unfortunately people don't have any other choice. But what we say is make sure at the very least that your executor is Australian based, right? They're based here in Australia, and that they have a direct line or contact details, and we would include these contact details. We have drafted wills whereby the guardian to be appointed is an overseas guardian in the event both biological parents pass away. And in that scenario, believe it or not, we include a contact number, passport details, residential address of that overseas guardian so that the executor can at least communicate with them once the parents have passed.
All right, I think that brings us to an end of the questions. Everything else I think has been addressed. Ramia, Jazakallah khairan, thank you so much for your time and that valuable insight. I just wanted to remind everyone, inshallah, so what MuslimWills offers is that simple estate solution. If you do have a complex estate or some of those factors which can contribute to an otherwise simple estate becoming more complex, and you wish to reach out to Ramia, you can contact her through her firm at Law Bridge Lawyers. You can also send us an email and we can send you the contact details in writing. We also have about 4 other legal firms that do estate planning and management and provide legal services. We are not affiliated or associated with any of them other than the fact that they are experts in Islamic, or not experts, I should say. They do provide Islamically aware services in relation to Islamic wills and planning. So if you want details of those referral partners for you to be able to seek further legal guidance, please email us and we can send you those details. In terms of charging, each firm charges their own fee, so it's up to you to contact them and see what the fees are. But as I think has become abundantly clear, sometimes taking that precautionary step prior can actually save you, a headache and other issues down the track. The final thing is, if we've got any financial advisors or tax agents or lawyers on this call that want to learn more about estate planning from a wealth management perspective, we have a very specialized session this Thursday, 7 August, from 5:45 to 7:45 p.m. It's a specialized session only for lawyers, tax agents, and financial advisors in relation to this issue of estate planning. So if you're interested, please just shoot us an email. We'll send you the details. And I think, they've just put it in the chat box. So you've got those details in the chat box. So let's leave it at that. Without further ado, Jazakallah khair. Again, thank you so much, Ramia, for your time. This session is being recorded and inshallah will be emailed to all participants. And inshallah, we'll see you at future Awqaf events. Jazakumullah khairan. Wassalamu alaikum and good night.
Thank you. Assalamu alaikum.
Alaikum assalam.